Hello everybody, this is Aishley Verma, an intern with LEXIS and Company, and today in this video I will be dealing with a case named Union of India versus Pradeep Vinod Construction Company. Citation of the case is Civil Appeal number 6958 and 6959 of 2009. It was appealed in the Supreme Court of India. The bench, talking about the bench consists of Justice N.V. Raman, Justice Ajay Rastogi, and Justice Mohan M. Shantan Godar. The date of the judgment is 27th August 2019. Head notes of the case include Section 11 of the Arbitration and Conciliation Act 1996 and Section 3G Clause 5 of the National Highway Act 1956. Talking about the facts of the case are following. The relevant seminal facts are that the subject land comprising in Saibabad T State, situated in Mauza Purba, Damati, that is JL number 108 police station, Fansideva district, Darjeeling, measuring about 5.08 acres, was required by the appellant, that is National Highway Authorities of India, in exercise of its power under Section 3D of the Act of 1956. Which is also notified in the notification dated on 22nd November 2005 under LAP case number 4 clause 2004 and 5 of for the purpose of construction of the highways. Further, in the instant case, the respondent applicant being dissatisfied with the award of compensation determined by the competent authority under section clause 1 of section 5G of the Act, filed application for appointment of arbitrator in terms of section 3G clause 5 of the central government to the central government on 8th December 2006. Further, as alleged, since the central government has not responded to his request, he filed another application on 7th March 2007 to the Chief Justice, and he is designate for appointment of an arbitrator invoking section 11 clause 6 of the Act 1996. It reveals that the arbitrator was appointed by the central government sometime in April 2007. The High Court of the Calcutta, taking note that the fact that the arbitrator had been appointed by the central government under section 3G clause 5 of 1956 Act, after the respondent applicant had moved an application to the Chief Justice, his designate invoking its power under section 11 clause 6 of the Act of 1996. So the section 11 clause 6 of the Act of 1996 held that the right of appointment of an arbitrator by the central government stands forfeited, as it failed to appoint the arbitrator until filing of the application under section 11 clause 6 of the Act of 1996 before the High Court of Calcutta, and the appointment of the arbitrator during the pendency of the proceeding cannot be said to be valid appointment, and hence referred the matter to be placed before the Chief Justice for naming an arbitrator, that is in its order dated on 6 July 2007. Immediately after the passing of the order dated on 6 July 2007, the appellant moved an application for review, and it was brought to the notice of the High Court that the Act of 1956, being a special enactment laying down a procedure for the appointment of an arbitrator where the power is being exclusively vested in the central government under section 3G clause 5 of the Act of 1956, the application made under section 11 clause 6 of the Act of 1996 is not maintainable, but it was not considered to be a valid reason for invoking review jurisdiction for the High Court as envisaged under Order 47 Rule 1 read with section 114 of CPC, and the review application was dismissed, which can also be noticed in order which was dated for 27th August 2007. So, talking about the issue which is involved in the case is there is just one issue, that is whether the application under section 11 of the Arbitration and Conciliation Act 1996 is maintainable in view of Section 3G Clause 5 of the National Highways Act 1956, which provides for an arbitrator by the central government. So is it maintainable? That is the only question arising in this case. Further, talking about the judgment, so the judgment held by the court are following. It is indeed true that the arbitrator who was appointed by the central government subsequent to the filing of an application under section 11 of the Act of 1996 in 2007 April could not be proceed after the arbitrator was appointed pursuant to the order impugnant in the instant proceeding, who too has later recused, and almost 12 years have rolled by now. We deem it appropriate to observe that there is no need to file an application by the respondent applicant, and the central government shall consider the appointment of arbitrator in terms of section 3G clause 5 of the Act of 1956 within a period of 30 days with the prior intimation to the respondent. Also, as the litigation has consumed a sufficient long time, we consider it appropriate to further observe that the arbitrator so appointed by the central government may adjudicate and decide the dispute within a reasonable time, but in no case later than 6 months after the respondent applicant record its presence in the proceeding. Also, the appeals accordingly succeeded and are allowed. The order passed by the High Court dated on 6 July 2007 and 27th August 2007 are hereby set aside. The arbitrator may be appointed by the appellants in terms indicated above. Also, no cost was awarded. So this is it for today. Hope you like it. Thank you so much.